So now we move in to hear from Frank. He's the tribal attorney with the White Earth Band of Ojibwe, and he is the lead attorney in this case. And so, Frank, I first want to ask, do you want to speak first before we get to some questions?
Mari, thank you very much. Thomas did a great job of updating everybody on everything. It was nice to listen to all of that, not have to say it all myself. So why don't we try some questions, just looking at the time that we have to work with.
Okay, we have plenty of time. So first, Frank, a couple of questions about this idea of where we go from here. Can you, Thomas gave us sort of the bread and butter of the case itself. What do you see as happening and coming next in this case and with line 3?
Thank you. I see a couple of different pieces. You know, for us, line 3 isn't over. You know, line 3 still has problems that need to be fixed and identified thoroughly. And I think that's part of the reason the DNR is hiding right now and doesn't want to participate, I guess, in what's going on with the 5 billion gallon dewatering permit. So just to kind of bring those pieces together a little bit, since the pipeline has been connected and we understand that oil is flowing through it, the actual construction sites, primarily the water crossings, they appear to have a variety of frac outs, and they have also breached some artesian aquifers. And so part of the concept of dewatering is allowing the millions of gallons of water that's been leaking out of the aquifers to also go forward. The DNR tried to stop or get the Enbridge to stop it. They haven't stopped it. They fined them $3.3 million. That's the price of them selling our resources off without our consent again, which is very scary. And so when I look at what's going on with Manoomin and with what the future of that is, I think we're not only going to have to continue with our litigation in tribal court, which I think is very important, but I think also we're going to have to look at maybe adding another party, maybe the Minnesota Pollution Control Agency, because they also have a role in this. They have supposedly identified 28 frac outs, but they don't want to identify the locations of those places. What I'm seeing out there is that they're hoping that they can just go home. No one will look at these sites. There's nothing to look at here. But Ron Turney's been doing a really good job with a lot of the drone footage. We've just had a flyover with thermal imaging. And so we're going to identify those places. We're going to make sure that they're followed up on it and protected, and that we use that same information in the same way as line 3 converts over to line 5 in northern Wisconsin and what's going on in Michigan and things like that, because it's all similar terrain and it's all vulnerable to the same kinds of poor planning and poor execution of the construction plans. And so I think what's happening here may very well be what causes the stopping of new pipelines in North America, and may very well be the rebalancing of environmental tools and scales between tribes and states. And if tribes have the ability to require consent, then I think that's going to make the states have to think a lot more about how they go forward with their permitting, if they do at all.
Okay, so picking up on that, Frank, can you just speak a bit more to this idea of, you sit on the 18.5 Treaty Authority, you work on treaty right issues all the time. Can you tell us a little bit more about the impacts of this particular place on White Earth Band's ability and other tribal nations' ability to protect their treaty rights, their rights to hunt, fish, gather? Can you just talk to us about it, perhaps just for White Earth, if you want to talk about from that perspective, but just in general, what do you see the implications of this case being for the ability of a tribal nation to protect its treaty rights?
I think it's very important for all of the Chippewa. And, you know, Tom talked about the 44 treaties that we have with the United States. And our territory basically runs through the Great Lakes into North Dakota. And we have the same treaty rights. And those treaty rights really are meant to not only be able to protect our rights to hunt, fish, and gather, but to also protect the resources so that we are always able to hunt, fish, and gather, and that those who come after us in perpetuity will be able to enjoy those same benefits and rights themselves. And so when I look at what's going on, I think the state of Minnesota, the DNR, the PCA, with permitting all kinds of different activities, they have exhausted our resources. They've exhausted our resources without the consent of the people, without the consent of the Ojibwe, the Chippewa, the Anishinaabe, however you'd like to call us, our treaty rights. And, you know, as that one slide from, I think it was on the third page or so with Article 5 of the 1837 treaty, it talks about the rights to hunt, fish, and gather on the land, wild rights on the lands, rivers, and lakes in the territory being ceded. That is a big statement. That means everything in the garden is still subject to our rights to access and to feed ourselves forever. We're talking about food sovereignty and food security. And that's what kind of comes back to some of the tribal sovereignty and the enforcement mechanisms, because if we can't defend our food sources and if we can't defend our cultural sources, especially with rights to Manoomin, then as the judge said in the part there, then it's meaningless. It's a fiction of law. And we should have the right to protect wild rice in particular because it is named in the treaty. Treaties are the supreme law of the land according to the US Constitution. And so I think in this circumstance, this may very well be the turning point, I think, for a lot of the work that you guys have been doing with rights of nature, finding a way where there's a forum that has a leg up on state agencies that have been actually permitting all the pollution.
And Frank, from your perspective, you worked on advancing the rights of Manoomin law with the White Earth Band. Can you talk to us beyond this case? What do you see as needed in terms of policy or lawmaking at a tribal level with White Earth or other tribal nations, at a state level, or even at the federal level?
Well, I think there's going to have to be more than what is normally called co-management. Co-management seems to leave secrets between the two parties about what's going on and things like that. I think if consent is required, then I think people are going to have to really be forward and honest about what they're going to do, because otherwise they're not going to get there through the process, any kind of public process that they're giving notice on. And I think this is going to improve the way resources are looked at, because if we don't start protecting the resources even now at this late date, then we may not have a whole lot to protect. There are thousands of waterways and waters in Minnesota that are impacted already, where you don't have the same kinds of fish, you don't have the same kind of vegetation, you don't have the same water quality. And so people are concerned about not just the environment, but even those who have lakeshore property are concerned about the value of their property if these waters are degraded. And that's what's been happening. And so I think that when you look at what this litigation is about with the rights of Manoomin, it all comes back, I think, to really rights of water. And that's a lot of what the organization has been working on too, is rights of nature, rights of rivers and things. But Manoomin, for us, I think transcends the law into the cultural, spiritual side of things and makes it a lot harder to say that law doesn't make sense. That law makes perfect sense. And every tribal member knows exactly what that law is about. So I think it's groundbreaking is what my friend Joe, another tribal attorney that I'm working with, is. He thinks it's groundbreaking, and I think other people do too. And I think that's why there were 7 Chippewa bands who were on the amicus brief for what's going on in the 8th Circuit right now, because they see the power and the opportunity to change the balance in the environmental world of protection.
Yeah, let me ask you this. As folks who are watching may know, the Biden administration recently, just in the last week or two, announced this interagency agreement among 17 different federal agencies. The agreement is focused on increasing consultation with tribal nations on federal treaty right obligations. And I wonder, Frank, what your perspective is on this new interagency agreement that the Biden administration put into place. What difference it will make, or how do you think it might impact Manoomin and what you're doing?
Well, I don't think it's going to impact what we're doing very much. If anything, I think it's almost camouflage or a fig leaf for what the Biden administration is doing. Personally, I think that the Biden administration has kind of sold us out here with regard to Line 3 and protecting our waters, having the Corps of Engineers go through with an environmental impact statement and things like that. And they've fought us in federal court about that as well. What I'm seeing even more so right now in regards to the water quality, because water quality is what's going to affect Manoomin, is also with regards to the mining that's going on in Minnesota. There's PolyMet's been in a 10-year fight. and there's been a recent Supreme Court decision there from Minnesota, and that, you know, there may have to be other enforcement by the PCA with regard to water quality permitting, water quality standards. And I don't think that the PCA knows how to go forward and start defending the resources very well yet. And so with the mining, what we see is copper, nickel, and other exotic metals. Recently, I saw GM come out and they said that we need to have these metals right now. From Tesla, the same thing. They said, you know, we want to have anybody who's involved in mining copper, nickel, and these other metals, we need them to be actively doing more of that right now. Those places are in the same exact places where wild rice grows. They're the same places that the pipeline went through. And so we believe our resources are being sacrificed by the Biden administration so that there can be this new access to metals and things for what people call the green wave, for solar energy, for cell phones, and for things like that. And so in reality, what is and isn't green and what they're talking about with treaty rights, they may help people down the road. But I think right now, I think what we're doing for ourselves with rights in Manoomin is going to do a lot more for ourselves and for tribes across the United States. And I think you're going to see the other state attorney generals and other people start to look at how to maybe more respectfully conduct themselves and consult with tribes about what they should or shouldn't be doing in the environment. I don't think whatever's happening at the federal government is going to happen soon enough for everything that's going on, because Joe Biden says he wants to have all these electric cars accelerated. I get that, but that comes back to extracting those same exotic metals, and it comes back from doing it right at the Mississippi River waterways and things like that. So it's not good for us. It's not good for the planet. It's not good for anything that's going on. And we still have to fight Line 3, and we have to prevent what's going on in Wisconsin from those same kind of waterways, the waters of the Great Lakes, Lake Superior. It's really, I don't see the Biden administration talking about it. They want to talk about the future, I think, not tomorrow and the next day and the next couple of years. They want to talk about 10 years from now. That's all rosy scenario. I'm all up for it, but how are we going to get there from here? And how are we going to get there safely and protect the resources we have now that we know are being targeted and being degraded?
So Frank, we have had several people ask about Attorney General Ellison in Minnesota. One is specifically when we say that the state Department of Natural Resources is fighting this case, who is representing, particularly who is representing the department in this case? So that's one question. Then I'll ask you the second question. Is it the Minnesota AG that's representing the department? That's the question that we've received, or is it somebody else?
No, it is the attorney generals. There used to be something like a couple hundred attorney generals that work for the state of Minnesota, and usually there's a half dozen to a dozen that work for each state agency, depending upon the size and the amount of work that's involved. And so we have attorneys who are directly working for Keith Ellison's office in the sense of the hierarchy, but they, as far as I know, they're based right with DNR.
Okay, and then a related question is, where does Ellison sit? I think maybe many of us have heard his name quite a bit with the case related to George Floyd's murder. And so I think his name is sort of more popular than it might otherwise be. Where does he sit? You know, what is his perspective on this case? Do you have any sense of that?
Well, he sits all over, and he hopes to, you know, certainly be on the right side of things and be reelected. You know, Keith Ellison worked with legal services as an attorney a long time ago in Minneapolis. He understands, you know, the plights that have happened to Indian country over and over. And he also understands what we're doing right now is going to turn the page and show that Minnesota is going to have to learn to cooperate and step up and become cooperative with the tribes. And he should take that leadership role before we have to go to court and do more litigation against them. There's a better way to solve this, and it's through communication, consultation, cooperation, and consent. And we can do it the other way, but I think that it's scaring the other state governments as well, and those attorney generals, because they see that what Minnesota is doing in federal court is opening up their vulnerability to the tribes that are in their states as well. And so Keith should be thinking about what the decision is going to be from the 8th Circuit Court of Appeals as well for the rest of the United States.
Okay, so one of the questions that was posted in the chat was, is there a feeling that the state is putting up such a fight on this by not only appealing in tribal court, its motion to dismiss, which was rejected by tribal court, and appealing that, but also moving in the federal court? Is there a sense, the questioner asked, that the state fear that it could lose this case?
Yes, I think they are worried about that. All of the actions, I would say, in tribal court themselves are the same kind of actions I would have done for lack of jurisdiction, and I've filed in state courts against, the DNR or whoever. And I'm doing that right now, even with the Line 3 water protectors. So that part all seems normal. Normally, in law, you can only be arguing things in one place. And the DNR has said, well, we don't think you have the right to decide here in tribal court, but just in case, we're going to appeal right now in the federal court. That looks really weird. Nobody is supposed to be having two games going on at the same time over the same issue. That tells me that the DNR is very afraid. They don't want to go through the tribal court process. They want to accelerate the answer no. And they're not going to get to the answer no. And it's going to be very interesting to see what they do in the 8th Circuit basically upholds the federal district court in Minnesota and says, you have to go through and exhaust your administrative remedies. We don't have a way to stop the tribal court from exercising jurisdiction over the state. That was what the judge asked. What authority are you citing to that gives me the right to tell the tribal court that they don't have the right to exercise their jurisdiction to protect Manoomin? The DNR had no answer.
Okay. Another question that's come up is, because oil is flowing through Line 3, what does this mean for the case?
Well, in some ways, it means the same thing that happened with Dakota Access. I mean, the federal court there has said, hey, turn off that oil, and we're going to do the environmental impact statement the right way. So in that sense, we're going to probably end up with the same kind of a concept with federal court and stuff. And that could still come out of the case in the DC circuit against the Corps of Engineers. But I think we're going to look at being able to turn off the oil in a different way, because it's a different jurisdiction than federal jurisdiction, and it's different than state jurisdiction. And if you're inside of our ceded territories, and if you're willfully exercising, the destruction of our planet, our resources, the climate change and things, they've already had valve turners that were tried in Minnesota, and they didn't have another way to stop what's going on. If Enbridge can't obey the federal court, then it's really limiting the opportunities or the rights of people to protect themselves. And it may very well be that there could be a different court order that says shut that valve off, and it may be looked at as a civil matter rather than a criminal matter, and it may be within our jurisdiction to do that, even though we haven't tried that before. So I think there's things coming down the road that I haven't even thought about, and that other people are going to start realizing the opportunities, and we're going to learn from each other. And we're going to find a different way to physically exercise our jurisdiction, because they can't be allowed to just thumb their nose at us and continue to pump the oil and get away with, not having to comply with the court orders we would all have to comply with. They have only been charged with a misdemeanor for all the water destruction that they've done. Water protectors themselves are facing, felonies and things like that for exercising their rights to defend the water and defend the Manoomin and prevent more climate change problems and things like that. So this is probably the legal reckoning on a number of fronts, and it may very well be that tribal court is going to be the place that does it.
Okay, so Frank, two last questions which are related. One is, what do you see as needing to happen, or you'd like to see happen with other tribal nations that would either be, service and solidarity, or of use in terms of valuable in terms of this particular case?
Well, I think I'm already getting the solidarity from the amicus brief bands there, those Chippewa bands. That I thought was really a good showing that we all see our rights being impacted the same way, and we all want to exercise our rights the same way. I look out west at the Klamath and the river out there with the York tribe, and I look up in the northwest part of Washington. And right now, one of my friends up there, Jack Feander's got a case going on where they're looking at the 3 dams that create hydroelectricity for the city of Seattle are also the same things that are impeding the salmon from getting upstream to the place that they said, yeah, we'll stay and live as long as we got our food coming upriver, but they're not getting it. So it's going to be very interesting to see what a fully lit city like Seattle at night, if you've ever seen the skyline, and that's part of what they do with their legal work, is to show just what's being taken from them and those expenses. And it may very well be that treaty rights are going to change those kinds of landscapes all across the United States. It might be slow at first, but it's getting the ball rolling and people seeing, is it the rights of fish? Is it the rights of trees? Is it the rights of wild rice? What needs to be protected, and how do we go about crafting that in such a way that, the state can't permit further destruction.
Okay, and related, for those of us just out in the world, learning about this, whether we're activists or part of a group or just really interested in what the work that you're doing, what sorts of things can folks do to be helpful?
Well, right now, probably the most helpful thing is, I know that there's a different, we're at a different phase right now with the water protectors, so we still have the legal defenses going on for that, and people are still working on raising funds and helping those water protectors out as we go through those parts. But probably more importantly, what we're looking at right now is the actual monitoring of the frac outs and of the aquifer breaches and what's going on there. Because one of the things that I learned recently, and it makes sense, but until you hear it, sometimes you don't know. But the people that did our flyover with their airplane, they're looking at a temperature probably, say, from ground temperature of, say, 25 degrees to water temperature that could be 40 or 45 degrees. And so they can even detect frac outs and aquifer breaches under the water of the Mississippi River that we wouldn't normally be able to see, just because it's probably 40 or 45 degrees coming out into 35-degree lake, river water and stuff. And so we're going to be looking for all of those places that the DNR and the PCA have walked away from. And we're going to make sure that people understand how the people who did the construction plans didn't follow those plans, how they secretly circumvented the protections that were supposed to be put in place so that we didn't have these kinds of things happening, and how we hold those people accountable. And this is going to be the model for the future. It's going to be the model for the Chippewa, and it's going to be the model for all the water protectors across.